Good morning, everyone. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, November 17th, 2021. The time is 9:30 a.m. And with us today are Commissioners Emily Lindley and Bobby Janecka, as well as our General Counsel, Mary Smith. I'm John Neerman, and I'd like to note that most of the participants are joining us today virtually, so please remember to keep your lines muted when you're not speaking. And if you're here only to listen, you can watch the meeting online, and that link is available on our agenda notice. For each item where discussion or argument is allowed, we will inform speakers of their time limits. Registration has now closed, but if you'd like to address the commission on a particular item, please email agenda@tceq.texas.gov with your name, your affiliation, and the item you'd like to comment on, and we will do our best to accommodate that request. For those who are making presentations, please wait until I or our General Counsel have asked you to begin speaking. And again, please remember to check that your line is unmuted. With that, I'd like to thank everyone for being present today. Ms. Smith, I think we're going to take up Old Business 1 together with the enforcement docket, so I'll ask you to call New Business Item 1.
New business item 1 is the consideration of the proposal for decision and proposed order concerning the application by Regal LLC for new TPDES permit number WQ001-581-7001. The parties have been notified that the applicant, the protestant, the ED, and OPIC will each have 5 minutes of oral argument time and will present in that order. The applicant may reserve a portion of its time for rebuttal as it bears the burden of proof in this matter.
Good morning, Mr. Tuckfield. I think you're up first.
Thank you, Mr. Commissioner, Mr. Chairman. My name is David Tuckfield. I'd like to reserve 2 minutes for rebuttal. This case is about regionalization, nothing but regionalization. And these findings of facts, conclusions of law are the most critical issues that we have in front of us here. This finding of fact 51 says, despite attempts by both Regal and the city, the city's system is unavailable. And conclusion of law 20A, which came as a result of the exceptions, is also critical. For purposes of 26.0282, a collection system that has a physical being exists unless service from it is unavailable. In other words, sure, it exists, but for purposes of regionalization, it does not exist if it's unavailable. And that's the crux of what happened here, okay? How do we know that it's unavailable? Well, surely we have finding of fact 51 that we've already talked about. Finding of facts 48 through 50 also talk about the unavailability and how Regal spent months or years trying to get a connection to the city. And this shows, this demonstrative shows down here is the development. They tried many different ways to get up to a connection to the city, but this massive ranch was between them and the city, and that both the city tried and the applicant tried, everybody tried for significant time to try to get an easement. They were unable to do it. This is discussed in the PFD at page 20, footnote 69. The city witness testified, testified that they're not trying to get, even though they have eminent domain powers, they're not doing it, and they haven't done it. So essentially, the system was unavailable. Now, the real problem here that we see is some of the findings of facts that talk about falsification. The truth is, if you accept, again, conclusions of law 20A, and this is straight from the mid-text decision that you all decided in 2005, the system doesn't exist for regionalization purposes if it's unavailable. When the application was filled out and they were asked if there was a regional system within 3 miles, if the only guidance available at the time was a mid-text decision that says that system is unavailable. So we believe, and I hope that you've been able to read our exceptions, that we believe that there was no falsification, and those findings of facts need to change as set out in our exceptions. Also, we cite numerous cases in our exceptions that show that capable also means available, and availability is a word that is used in 26.0282. So availability is critical, and I'll stop with that right now. And the bottom line is there was no falsification, and this permit should be granted.
Thank you, Mr. Tuckfield. Any questions for Mr. Tuckfield? Commissioner Lindley? Commissioner Janeka? All right. Thank you, sir. Good morning, Mr. Rodriguez. Go ahead when you're ready.
Thank you. Mr. Chairman, Commissioners, General Counsel, Office of Public Interest Counsel, and the Executive Director staff, thank you for the opportunity for giving me to be heard this morning. My name is Art Rodriguez. I'm with Russell Rodriguez Hyde Bullock, and I represent the city of San Marcos in this case, and I'm joined today by the Director of Utilities for San Marcos, Tyler Yorth. He's participating online this morning. This is one in a long line of permit applications that the city of San Marcos has protested and will continue to protest. As the Commission's aware, there is no guidance documents, no rules or policy that deal with the state's clear preference for applications like this one to be dealt with on a regional basis. This case is a clear-cut example of how applicants can manipulate the process to refrain from any regionalization review and commit a fraud on the Commission. Your instructions for TPDS provide that if there is any permitted domestic wastewater treatment facilities or sanitary sewer collection systems located within a 3-mile radius of the proposed wastewater treatment facility, provide a list of these facilities, including the permittee's name and the wastewater permit number. That's in your instructions. The application itself, sorry, my iPad just went crazy on me. The application itself states, are there any domestic wastewater treatment facilities or collections located within a 3-mile radius of the proposed facility? The applicant answered that question, no. As the Commission staff is required to rely on the applicant's erroneous information, the staff admitted that it did not require any further information from the applicant. However, even when the city provided evidence that there are facilities within 3 miles of the facility, the executive director staff didn't ask for any additional information, didn't even ask why there wasn't any additional information in the record. This, excuse me one second. When technology fails, have a hard backup. When the city raised regionalization as a concern and requested that issue be referred for hearing, the Commission staff did not return to the application and inquire where the regionalization information was, or ask why there isn't any regionalization information in there. It just steadfastly held to the support that was provided in the application that was facially deficient and fraudulent from the date of its submission. Thus, in essence, it has completely ceded all regionalization efforts to applicants without performing a modicum of regionalization analysis for the applicant, particularly in this case. The only loser in this type of analysis is the environment by introducing an unnecessary additional point source of pollution into our rivers. The only credible cost estimate provided in this case was provided by the city, which showed the amount for connection to the city is reasonable. The connection that was introduced by the city was provided by the city's engineer, who is also their capital improvement specialist, who showed that the connection was 6,800 feet from the property to the nearest facility of the city. There is no other contravening evidence or controverting evidence that shows that it's any further than that. It's based on analysis from the city's engineer who's responsible for planning the city's wastewater system. It's clear-cut that the applicant is trying to game the system and perpetuate its fraud on the commission. Additionally, the lack of rules of regionalization allows commission staff to engage in ad hoc rulemaking to simply allow every applicant to pass a regionalization review, which is mentioned in the statute in multiple areas. The commission cannot allow applicants to flaunt the state statutes on regionalization and continue to manipulate the application instructions in order to prevent staff and the public from providing true cost comparisons and benefits in order to protect the environment. The applicant in this case misrepresented itself in a most egregious manner. The city requests that the commission send a message to all applicants that regionalization is a factor. It's stated clearly in the statutes, and that it is a factor to be considered by the commission. Misrepresenting facts, clear instructions, clear not only in the instruction documents, but clearly stated on the application, will not be allowed. Applicants should be made to submit truthful applications. I think that's a cornerstone of the commission and should be upheld in this case. The only decision to be made in this case is to deny the application because it's facially deficient. No regionalization review was done, and it should be denied. Thank you very much.
Thank you, Mr. Rodriguez. Colleagues, any questions for Mr. Rodriguez? See none. Thank you, sir. All right, let's hear next from the executive director staff. And you might check your mute button. We're still hearing nothing from ED staff. Well, maybe let's take this out of order. Is there someone from the Office of Public Interest Counsel on the line? Well, colleagues, we may have a technical glitch.
I'll absorb that correlation is not causation just because Commissioner Lindley is present today and the second of technical difficulty agendas we've had in recent memory. It sounds like they can be heard on the webcast, if that complicates things at all.
So we may be able to, I wonder if we can figure out a workaround.
Do we have a workaround?
Yes, we're going to connect it to a microphone, I think, in the room through a phone.
Let's give it a shot.
Give it a shot.
So we've been doing these remote, virtual, or hybrid meetings for over a year, and this is the second technical glitch we've had, so maybe we should be grateful for that, but they are inconvenient, especially when they show up on the first item.
For those members of the public watching, I believe that the YouTube doesn't have any, it's not capturing that audio either. So we've got, that reflects the agenda room, but the webinar, which is the platform we're able to control the participants a little more than just an open line. Little detail for the audience who are, I'm sure, morbidly curious about what's breaking how. My first job is tech support.
Followed by the pound or hash sign. To enable audio controls, please enter your audio PIN followed by the pound or hash sign. If you do not have a PIN, please enter your access code followed by the pound. To enable audio controls, please enter your audio PIN followed by the pound.
Bobby, can you hear me?
I can hear you. Can you hear me?
I can hear you. Chairman, can you hear me?
I do, and I think everyone in the room can hear you.
Awesome.
So I think we're back in business.
Okay.
Thanks, everyone, for their patience. And we'll turn it over to Executive Director Staff at this point.
All right. Thank you. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. I'm Bobby Salehi with the Environmental Law Division. With me today is Feroz Bahora of the Water Quality Division. The Executive Director agrees with Judge Farhadi's proposal for decision to issue the draft permit in this case. Thank you, and we're available for any questions that you may have.
Thank you. I have none. Colleagues, any questions?
No questions.
Let's hear next from the Office of Public Interest Counsel.
Good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, Attorneys, and staff. I'm Amanda Pessinen for the Office of Public Interest Counsel. OPIC supports the Administrative Law Judge's proposal for decision and agrees with the ALJ's recommendation that the Commission approve the application of Regal LLC and issue the TPDES permit. In accordance with Senate Bill 709, applicants made a prima facie case that the draft permit meets all state and federal legal and technical requirements such that it would protect human health and safety, the environment, and physical property. The protestant, the City of San Marcos, failed to refute this prima facie demonstration. As explained in the ALJ's PFD, Regal's motion for summary disposition was granted on issues 1 through 4, 6, and 7 as referred to SOA in the Commission's interim order. Thus, the only remaining issue for hearing was issue number 5, whether the Commission should deny or alter the terms and conditions of the draft permit based on consideration of need under Texas Water Code Section 26.0282 and the general policy to promote regional or area-wide systems under Texas Water Code Section 26.081. In accordance with Texas Water Code Section 26.0282, in considering the issuance of a permit to discharge waste, the Commission may deny or alter the terms and conditions of the proposed permit based on consideration of need, including the expected volume and quality of the influent and the availability of existing or proposed area-wide or regional waste collection, treatment, and disposal systems not designated as such by Commission order. In considering the availability of the city's wastewater system to Regal, as discussed in the ALJ's findings of fact 48 through 51, Regal and the city identified several routes through which Regal could connect to the city's system, but each route required that Regal obtain an easement from the landowner of a parcel of land referred to as the JK Ranch property located between Regal's development and the city's nearest wastewater collection line. Regal and the city made significant efforts to connect to the city's system by attempting to acquire an easement through the JK Ranch property, but the landowners of the JK Ranch property refused to grant an easement. Thus, despite attempts by both Regal and the city system is unavailable for a connection with Regal. These findings support the ALJ's conclusions of law number 21 and 22 that service is not available to Regal's property from the city's existing collection and treatment system, and that the Commission should not deny or alter the terms and conditions of the draft permit based on consideration of need and the general policy to promote regional or area-wide systems. OPIC finds these findings and conclusions are sufficient to support issuance of the draft permit. While OPIC agrees with and recommends adoption of the ALJ's overall conclusion and that the draft permit should be issued, OPIC recommends against adoption of some of the ALJ's findings of fact and conclusions of law as they are unnecessary to support the ultimate decision in this case. OPIC recommends against adoption of findings of fact 37 and 38, as well as conclusion of law 19, which concern the issue of annexation and address the question of whether the city's annexation requirement amounts to a denial of service. Because this case can be decided based solely on the unavailability of the city's system to Regal, the question of whether an annexation requirement is tantamount to a denial of service need not be resolved in order to reach a sound decision in this case. Similarly, OPIC also recommends against adoption of findings of fact 39 through 47 concerning misrepresentations in Regal's application. Although OPIC agrees with the ALJ's findings on this matter, these findings are also unnecessary to support the decision in this case. In summary, OPIC supports the ALJ's conclusion that the City of San Marcos' wastewater system is unavailable to Regal and that the draft permit should not be denied or altered based on considerations of need or regionalization. Nonetheless, OPIC would also support a decision to decline to adopt findings of fact 37 through 47 and conclusion of law 19, as they are unnecessary to support the ultimate decision in this case. Thank you, and I am available for any questions.
Thank you, Ms. Pessinen. I have none. Colleagues, any questions for OPIC?
No, thank you.
All right, seeing none. Mr. Tuckfield, you've got 2 minutes.
Thank you, Mr. Chairman, Commissioners. I neglected to mention that the applicant and the engineer who filled out the application are here if you have any questions for them. Mr. Rodriguez noted that there's a strong preference for regionalization. This is not a mandate. It is a strong preference, and there are other regionalization issues at play here. For example, Crystal Clear is a regional provider, and they testified in this case. The fact is that he says it's an example of how applicants abuse the process. The fact is that what is happening here is this is an example of how cities can abuse the process to string applicants along for years, requiring that they connect when it's impossible, refusing to use their eminent domain power. And in this case, the City of San Marcos even requires consent to annexation before you can apply for wastewater service, circumventing that rule. So I agree with OPIC that the conclusion about annexation is incorrect, but it's probably irrelevant to the decision in this case. Mr. Rodriguez says there's no policy. There was no policy and is no policy, but the fact is that Midtex existed, and Midtex was the only available case that gave guidance to this situation. And the city's experts themselves adopted Midtex and agreed wholeheartedly with the Midtex decision, and the Midtex decision included this conclusion of law. And so that's the only thing our applicant had to go from. Staff knew about this question as illustrated by the response to comments. The response to comments raised the question of whether the applicant should connect to the city, and the staff noted in the response to comments that the system was unavailable. So Mr. Rodriguez's assertion that they should have done a financial analysis of this is ridiculous because you have a denominator of 0. It's impossible to do it. So it elevates form over substance, and so we ask that the permit be issued, and I'm available for any questions. Thank you.
Thank you, Mr. Tuckfield. Colleagues, any questions or observations at this point? All right. Well, we have just one issue before us, and that's the issue on regionalization. I'll cut to the Chase, the ALJ proposed that we issue this permit without alteration, and I agree with the ALJ. My analysis conforms pretty closely to OPIC's analysis, and that is that my understanding of the evidence is that there is no feasible connection of the Fleming Farm subdivision to the city's wastewater treatment system without an approximately 6,800 foot easement through third-party properties, and that despite the efforts over the last couple of years, both by the applicant and the city, to obtain an easement, none exists and none appear viable. And I think that those facts answer the question on regionalization and do clear the way to issue the draft permit. But I do want to address some of the ancillary issues that the parties have raised that relate to the form of the PFD. And I'll sort of take these just in numerical order, beginning with the findings of fact, and maybe pause to open it up for discussion at each one. I had not really flagged this issue so much, but OPIC urges us to strike findings of fact 37 and 38 concerning annexation. That's not something I had intended to do. There was an exception lodged to finding of fact 38 and concerning the possibility of waiver of the annexation requirement. That seemed fine to me. I didn't intend to alter that, but I thought I'd put that question to the two of you and see where you come out on findings of fact 37 and 38.
I can go first. I'm going to agree with you, Chairman. I hadn't planned on making any edits to those two findings of facts.
Commissioner Janeka, any thoughts on those findings?
I think I come down very, very close to where you do. I hadn't flagged either of those for any particular revisions, but I did note as well OPIC's comment on that and wanted to take another look.
We can give you a minute to do that.
No strong initial thoughts, yeah.
Yeah, take whatever time you need.
Okay, reviewing which those were. I think that comes similar to another line in this order that I had marked as grumbling about a bit, but not rising to the level of wanting to make changes or thinking that a change is necessary, but open to your thoughts.
Well, I would propose on 37 and 38 that we not alter them, that we leave them as they are in the PFD.
No disagreement.
Okay. All right, moving on. As for findings of fact 40, 41, 42, and 47, which assert that Regal provided false information in response to the questions on the Domestic Technical Report 1.1, those findings are not, in my reading, inconsistent with the evidence. For example, it is a fact that a domestic permitted wastewater treatment facility is located within a 3-mile radius of the proposed facility. And that is, of course, the city's wastewater treatment plant. And the applicant's assertion that there is no facility within a 3-mile radius is objectively false. And, I think city's council, if they want to, in argument, characterize that as fraud or gaming the system, I think that is not out of bounds, but that's not my conclusion. I'm not articulating a conclusion on intent or mental state. I don't think the PFD has articulated a position on intent. They just indicate that the information that was submitted was false, and I think the ALJ has characterized that appropriately. And as for ambiguity in the questions, I don't see anything ambiguous when we're talking about is there a wastewater treatment facility within a 3-mile radius. And even if there were, I think it's incumbent on the applicant to have a conversation with the permitting staff to ask them, help them clarify the ambiguity, or provide an explanation in their application, or do both. And I would expect professional engineers licensed by the state of Texas to exercise greater care and submit applications that are accurate. As it turned out, there was sufficient evidence in the record concerning the easements that allowed us to proceed, even though the staff's analysis of the regionalization issue was hobbled by the quality of the application. So the long and the short of it is, colleagues, I would not alter those findings of fact.
I agree with you.
I only want to add that I was disappointed that the applicant did not provide correct answers to those questions in the application instruction form, and I agree that their false answers deprived the executive director of the opportunity to dig into the issue further during that technical review phase. So I'm in agreement.
And moving to finding of fact 44, I do appreciate that at some point after the application was submitted, staff became aware of the city's facility, that the applicant and staff had conversations about that. Conversations that occur after the application has been submitted are no substitute for providing information that's required as part of an application. And in this case, that's well demonstrated, I think, by the fact that staff did not conduct a regionalization analysis because of the representations made by the applicant. And I think staff could have done that, so I'll ask staff to reflect on, what they how they might have approached this differently once they learned of the city's facility, even though it wasn't in the application. So, again, long and the short of it, colleagues, is I would not disturb finding of fact 44.
I agree with you.
Likewise.
Relatedly, and for similar reasons, I agree with finding fact 45 that the applicant should have provided a cost analysis.
I agree.
Okay, and as for finding of fact 46, there really is no policy. Neither the commission nor the executive director have adopted a policy, but there is a practice. So there's been some wordsmithing of that and some different variations suggested, including by the ALJ. I think it's most accurate to say that it is the ED's practice to not request additional information to verify the truthfulness of an applicant's response. And I propose that we make that edit.
I like that edit, yeah.
Likewise.
All right, so that takes us to conclusions of law. And this gets into the mid-text issue a little bit. And I'm referring to conclusions of law 19 and 20. And there's disagreement about how those conclusions of law are articulated. And in response to that, the ALJ has proposed an edit to conclusion of law number 19 and has proposed to add a conclusion of law 20A. And I'm concerned that all of these conclusions of law are overly broad and are not necessarily correct statements of the law. And I also don't think they're required to support this order. So my suggestion would be that we strike both 19 and 20 and that we decline to add 20A. And I think that mid-text sort of sent us down a rabbit trail in raising this issue of whether a facility exists or does not exist. The operative term in the statute is availability, and I think mid-text to a certain extent just traded in the word exist, and it leads to some discussion, some legal argument that frankly has me scratching my head about how a facility can have a physical existence and being, but still not exist for the legal analysis. I don't think that's helpful to the conversation or advances our understanding of what is available or not available under the statute. So I would just avoid that entire issue and, like I said, strike conclusions of law 19 and 20 and decline to add 20A.
I want to take just a minute and ask probably Mary and Morgan a question real quick. I'm
Sure.
in complete agreement on 19. I just want to double check on a question I have about 20A,
Okay.
if that's all right.
Do you want
Just
to do that now, or you
Sure,
want to get?
that's, I mean, shouldn't take long.
Sure.
If we might extend that a couple minutes, I'm going to step out of the room and be right back, if this is a good time.
All right, why don't we take is 5 minutes enough? 5-minute recess?
Yep.
Okay, it's 10:05, and we'll take a short recess. All right, the time is 10:10. We're back after a short recess. And colleagues, I actually think I'd made all the points I meant to make. I've prepared a motion consistent with that. Why don't we discuss the outstanding issues that you have with the analysis as I laid it out, and then figure out how to proceed. Commissioner Lindley?
Thanks for that break. I am comfortable deleting, with going along with what you proposed and deleting conclusions of law 19 and 20. And the only comment I'll make overall is, I'll be repetitive because you said it very well earlier, but it came down for me about easement feasibility, and I believe that's how you laid it out at the beginning. And, unfortunately, or fortunately, depending on who you're representing, I just think physically and legally it's not available right now. And that's kind of what it came down to for me. So I will be, with everything you've stated, I will be comfortable supporting and moving adoption of adopting the ALJ's proposed decision.
Okay,
I won't
make you second it until I've actually
Nope.
read it.
Nope.
But
Nope.
Commissioner Janeka?
I too am comfortable with your suggested changes on the conclusion of law, draft conclusion of law items 19, 20, and 20A. I'd come prepared today in agreement with you about conclusion of law 19 didn't appear to add much usefulness in citing that for future arguments or discussions. And I think in light of your comments, I gave a closer look to 20 and 20A, and I'm comfortable applying that finding to those as well.
All right, great. Well, let me go ahead and read a motion then, and can take any additional discussion on the other side. Colleagues, I move that we adopt the administrative law judge's proposed order with the following changes. 1, amend the ALJ's recommended edit of finding of fact 46 to read, quote, "It is the executive director's practice to not request additional information to verify the truthfulness of an applicant's response to the question regarding existing wastewater treatment facilities within a 3-mile radius," end quote. That we delete conclusions of law 19 and 20, and that we decline to add proposed conclusion of law 20A. I further move that we issue new TIPD's permit number WQ0015817001 to Regal LLC as recommended by the executive director, and that we adopt the executive director's response to comments.
I'll second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item number 2 is the application by Total Energies Petrochemicals and Refining USA Incorporated for air quality permit number 46396. The parties have been notified that the commissioners will not take oral argument but may ask questions. Those who have signed in will be noted for the record.
Thank you, Ms. Smith. For the benefit of those who are not familiar with our process, we have a 2-part analysis for considering requests for contested cases. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. And assuming that at least one requester has met the requirements, then we consider which issues are appropriate to refer to hearing. So part 1 is about who gets a hearing, and part 2 is about which issues are referred. Requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit and have done so both in timely comments and a timely hearing request are entitled to a hearing. Associations can have standing if they name at least one member who would have standing in his or her own right and raise issues that are both germane to the organization's purpose and relevant to this application. So, colleagues, on this item, we have a single request for a contested case. This one is by Mr. Hilton Kelly on behalf of Community in Power and Development Association, also known as CEDA. Mr. Kelly is the only identified CEDA member, and he fails to demonstrate that he is affected in a manner different from the general public. He identifies an address for CEDA that's more than 6 miles away, and he does not say where he lives, and he alleges temporary visits to locations near the facility, but he does that without specificity as to frequency or duration. I do want to note that Mr. Kelly had an opportunity to address these deficiencies and perhaps cure these deficiencies on reply, but he did not file a reply. So all this is to say that that CETA has not met the requirements for a contested case hearing. That's how I came out. Commissioner Lindley?
I'm in agreement.
Commissioner Janeka?
Likewise, and given the clear statutory landing there, I'll make the motion that we deny all hearing requests, issue air quality permit number 46396 to Total Energies Petrochemicals and Refining USA Incorporated as recommended by the Executive Director, and adopt the Executive Director's response to comments.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next item.
Item number 3 is the application by Texas Materials Group Incorporated to renew air permit number 8597. The parties have been notified that the commissioners will not take oral argument but may ask questions. We have over 60 individuals signed in on this item, and their presence will be noted for the record.
Thank you, Ms. Smith. Colleagues, I spoke about the two-part analysis for requests for contested case hearings, but as you know, there's also a threshold issue under Section 382.056 of the Texas Clean Air Act, which states that there is no right to a hearing for a permit renewal that would not result in an increase in allowable emissions. And the matter before us does, in my view, fall under the no increase renewal provision, so I believe we're compelled to deny the request for a contested case on this item. So that's where I come out on the action that's before us. I do want to note that this renewal does contain several additional provisions to address nuisance odor concerns, so the permit is more stringent in that respect and does provide greater leverage from a compliance and enforcement standpoint. And I'd just like to encourage the permittee to be a good neighbor, to stay on top of the odor issues, and to be keenly focused on compliance so that we don't have to get to that enforcement conversation. And I'll trust that the neighbors will help our investigators police compliance as well. So those are my thoughts on this item. Commissioner Lindley?
Well said. I'm in agreement with everything you said.
Commissioner
Likewise.
Janeka?
I've got a motion then. I would move that we find that there is no right to a hearing on this application pursuant to Texas Health and Safety Code, excuse me, Section 382.056, that we deny all hearing requests, that we issue the renewal of air quality permit number 8597 to Texas Materials Group Incorporated as recommended by the Executive Director, and adopt the Executive Director's response to comments.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item number 4 is the application by the City of Brackettville and Fort Clark Municipal Utility District for a renewal with major amendment to TIPD's permit number WQ 00101940002. The parties have been notified that the commissioners will not take oral argument but may ask questions. Those who have signed in will be noted for the record.
So once again, we have a two-part analysis. Part 1 is to determine who's entitled to a hearing. Part 2 is about which issues are referred. And again, requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit and have done so both in timely comments and a timely hearing request are entitled to a hearing. And colleagues, on this item, we have 4 requests, and they, in my reading, checked all the boxes, not all the boxes, most of the boxes for the procedural and substantive requirements. And so my analysis really comes down to proximity. And 2 of the requesters are situated close enough to the facility that they could demonstrate that they are personally affected, and 2 are not located close enough, in my view. So specifically, I would grant the requests of David Connolly Ranch and Dos Palmas Ranch, and I would deny the remaining requests. So let me pause there and collect your thoughts. Commissioner Lindley.
I agree with you.
Commissioner Janeka.
I found the same on those.
All right,
requesters.
turning to the issues, we refer relevant and material issues that were raised both during the comment period and as part of the hearing request. Relevant material means that they are within the commission's jurisdiction on this particular type of authorization. So for example, on a TIPDES permit, such as the one before us, surface water quality is within our jurisdiction. And another issue that's commonly raised, property values, is not within our jurisdiction on this type of an application. So with that said, I found the following issues to be relevant material, and I would refer the following issues. Whether the draft permit is protective of the health of the requesters and their families, whether it is protective of aquatic and terrestrial wildlife, and that includes any endangered species, whether it is protective of water quality and existing uses of the receiving waters, whether it complies with the agency's anti-degradation policy, and whether it contains sufficient provisions to ensure protection of water quality, and that includes provisions such as monitoring and reporting requirements. Just so I can round out the analysis, I think it does make sense to include an ADR referral on this, as well as to allow a full 180 days for the hearing.
I'm in agreement.
Entirely inconsistent with where I arrived on issues as well.
All right,
I
knocking
will-
them out of the park today.
And if there's any other discussion, I'm ready to plow forward with a motion.
Please do.
I think capturing all of those. I move that we grant the hearing requests of Dos Palmas Ranch and David Connolly Ranch, LLC, that we deny the remaining requests for hearing, that we refer the matter to the Commission's Alternative Dispute Resolution Program concurrently with the SOA preliminary hearing scheduling process, that we refer the application to SOA for a contested case hearing on the following issues. A, whether the draft permit includes adequate provisions to protect the health of the requesters and their families and aquatic and terrestrial wildlife, including endangered species. B, whether the draft permit is protective of water quality and the existing uses of the receiving waters in accordance with applicable Texas surface water quality standards. C, whether the draft permit complies with TCEQ's anti-degradation policy and procedures. And D, whether the draft permit contains sufficient provisions to ensure protection of water quality, including sufficient monitoring and reporting requirements. And I finally move that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next item.
Item number 5 is the consideration of gifts and donations with $500 or more in value given to the TCEQ. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Mr. Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Yen Chen of the General Law Division, representing the Executive Director. Before you are the gifts and donations received by the agency in the past 90 days. In accordance with Chapter 575 of the Government Code, the Executive Director has accepted these gifts and respectfully requests your acknowledgement of these gifts. As always, I'm available to answer any questions you may have concerning these items.
Thank you, Ms. Tran. I have none. Commissioner Lindley, any questions?
No questions.
Commissioner Janeka.
Likewise, none. I'll just translate a little bit. Those gifts and donations, 2/3 of them before us today reflect expenditure or travel reimbursement and training reimbursement from the federal government for our staff to go to training. So thank you very much for that. All good today.
Thank you, Commissioner Janeka. Appreciate that clarification. Moving on to the public. Any interested persons? Ms. Smith, is anyone signed in to speak on this item?
No one is signed in.
Okay, and that brings us to OPIC. Mr. McWhorter, are you there?
I am. Good morning.
Good morning.
OPIC recommends approval. Hello. OPIC recommends approval of the resolution acknowledging acceptance of gifts and donations as presented by the Executive Director.
Thank you for that. Colleagues, I agree. I think I'm ready to move forward with this item.
I agree. I will move that we approve issuance of the resolution acknowledging the Executive Director's acceptance of the gifts and donations contained in the TCEQ Interoffice Memorandum to the Commissioners dated October 29, 2021, docket number 2021-1325-RES.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Motion carries. Ms. Smith, please call the next item.
Item number 6 is the consideration of material changes to contracts for goods and services awarded under Chapter 2155 of the Texas Government Code that were executed during the previous quarter. The Executive Director's staff is here to present the item.
Good morning. And you might check your mute button.
I apologize. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Allison Scott, Compliance Evaluator for the Procurements and Contracts section of the Financial Administration Division. I am representing the Executive Director. This item contains the material changes made to contracts and purchases for goods and services between March 1st, 2021 through May 31st, 2021. Reported material changes include extensions of the contract or completion of work for 6 months or more, or an increase in consideration of 10% or more, in accordance with Section 2155.088 of the Government Code. The Executive Director presents these items for your consideration. I am available to answer any questions you may have.
Thank you, Ms. Scott. I have none. Any questions, Commissioner Lindley?
No questions. Thank you.
Commissioner Janeka?
Likewise, I appreciate the report.
Ms. Smith, has anyone signed in to speak?
No one signed in.
Mr. McWhirter, what do you think?
OPIC recommends approval of the resolution acknowledging material changes to contracts for goods and services as presented by the Executive Director.
Thank you. I agree. I've reviewed these items and I'm ready to move forward with approval.
Likewise.
I see head nods.
Yeah, it's
Good.
ever so useful. This is very, very useful and important information, and also tells us when we've increased the amount of our purchase price for pens by about $37 in a certain year because of the percentage change. I love state laws. I move that we approve issuance of the Executive Director's proposed resolution that acknowledges the material changes to contracts for goods and services in accordance with Texas Government Code, Section 2155.088, for the period of March 1st, 2021 to May 31st, 2021, as described in the TCQ Interoffice Memorandum to the Commissioners and Executive Director, dated November 17th, 2021, in docket number 2021-1290-MIS.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next items.
That takes us to our enforcement docket, which is old business, item number 1, and new business, items 7 through 40. The Executive Director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Susan Jablonski, also of the Enforcement Division, and Charmaine Backens of the Litigation Division, representing the Executive Director. Pending before you are our old business item 1 and new business items 7 through 40. The total assessed administrative penalties are $1,184,841, with $143,502 deferred, $295,613 applied for supplemental environmental projects, and $745,726 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Commissioner Lindley, any questions?
No questions. Thank you.
Commissioner Janeka?
No, thank you.
All right. And that takes us to interested persons. And I want to begin. This is my fault. I continued this, what's now old business 1 to this agenda because I had a question for the company, and I appreciate I see Mr. McDonald and Mr. Harvey are here and have signed in to speak. Thank you for being here. I'll ask you to step up. I have really just one question, and you're free to offer whatever comments or observations you like, but my question is, and it begins with an observation, and that is that TPC has had multiple violations of the same requirements. This agreed order addresses one of those, and my question is, what is the company doing to get ahead of this and achieve a durable, lasting compliance?
Sure. Yeah, good morning. Thank you for the opportunity, Chairman Neerman, Commissioner Lindley, Commissioner Janeka. My name is Derek McDonald with the law firm of Baker Potts. With me today is John Harvey, who is the plant manager at TPC. And we're both here to answer your question, but we wanted to give Mr. Harvey an opportunity to just introduce himself for a second and talk about the work that's going on at the Houston plant to continually improve the performance as well as the compliance of that plan.
Thank you. Good morning, Mr. Harvey.
Yeah.
Okay, so my name is John Harvey. I'm the plant manager at the TPC plant. I've been a product of the Houston area, most notably Cashmere Gardens, and I've been at the site for 5 months, but I've been a plant manager for over 35 years.
At this location?
5 months at this location, 35 years with both BP, INEOS, and others.
I understand. Thank you.
Most notably, I've managed both BP and INEOS's largest petrochemical sites in Chocolate Bayou for 6 years. I've just completed, before coming here, being at the site in Cooper River, South Carolina, where we had no recordables, no environmental issues for the last 4 years. So just letting you know that. I'm committed to an improvement of the site by way of me being here, showing you that I want to do what I can to improve the site, and just want to be able to answer any questions that you have.
Okay.
All right? And
thank you.
Okay, good.
All right. Well, what are the plans at this site to improve compliance? I appreciate, or I understand you've been there for 5 months. Maybe you inherited some plans,
Right.
and if you could speak to that.
I can talk about the plans there. The company has spent over $200 million on infrastructure. We've done work in terms of operational excellence, operational performance, and working with our employees in that area. And we're very committed to doing a lot of activities around both training, both the we have a permit that's reducing our overall emissions that's before you as well. So that's where we are right now.
Okay. Thank you, Mr. Harvey. Mr. McDonald, anything to add to that? I think I've exhausted my questions.
No, Chairman Ehrman, if you have anything else specific, we're here to answer them. But
Colleagues, any questions for?
I do not. Thanks for being here today.
Mr. Harvey, can I clarify that or make sure I understand that right? You just completed a visit to another TPC facility in South Carolina or another state that has?
I came from South Carolina.
Okay,
And,
okay.
Yeah, and I just wanted to let you know that my commitment to the site is that before here, I've had a very good spotless record, and I plan on committing myself to this plan to get there.
I appreciate that, and I just want to ask in your opinion, what's the single biggest factor that you see as a clear difference where you left a 4-year clean track record of another facility, which I see as a very good bragging point? What's the biggest difference there versus what you want to bring or see increased at this facility?
A couple things. One is the infrastructure, and one of the things that we're doing with the infrastructure is putting a lot of money into our boiler system and our steam system. One of the things that we have to do, this is a 75-year-old plant, and with that, steam is the lifeblood of a petrochemical plant, and they're putting a significant amount of money into the plant, and that's based on the permit that we have. And the permit is going to reduce the overall emissions as well. Yeah.
Thank you.
So it's based on infrastructure. Okay.
All right, I've got one other question for you.
Yeah.
Is there anything that the agency can do to support you in your compliance efforts? You know, we'll set aside the enforcement question. We always have that lever. We can move that lever. But if you have an answer or that you'd like to share in this forum or separately, you could follow up offline with me individually, not in an open meeting. But go ahead.
One of the things we have reached out, and we're setting meetings with Ms. Jablonski to kind of coordinate on some of the other issues. That there are some pending issues that unfortunately might come back before some of the work that's in place is completed. So we're coordinating with the enforcement staff on those, as well as working with regional staff on the inspections that are going on now currently.
All right. Well, thank you, Mr. Harvey. I hope you have the same success at the Houston facility that you had in South Carolina. We are certainly looking for that. The reason that this item caught my attention is, repeated violations of the same nature, and clearly that's not okay with us. So I appreciate you coming in and answering our questions about that.
Understood.
Yeah.
All right.
Thank you, gentlemen.
All right.
Ms. Smith, is anyone else signed in on the enforcement docket?
We have several people signed in on items 8 through 10, 12, 13, and 19. They're here and available to answer any questions, but they're not asking to address the commission.
Thank you. Colleagues, any questions or comments on the relevant to the other folks who have signed in with their availability?
None for me.
I don't think I have any questions for them. I appreciate them being here if needed.
All right, that takes us to OPIC. Mr. McWhirter, what do you think?
My office has reviewed all of these items, and we recommend approval of the orders as presented by the Executive Director.
Thank you. Colleagues, I agree with that. I think I'm ready to move forward.
I've got a motion. I see heads nodding. I move that we adopt old business item 1 and new business items 7 through 40 as recommended today by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. I forgot to say aye. So that's 3 of us. The motion carries. Ms. Smith, please call the next item.
Item 41 is the consideration of the monthly enforcement report, and the Executive Director's staff is here to present.
Good morning again.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me are Susan Jablonski of the Enforcement Division and Charmaine Backens of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2022 through September. There were 86 effective administrative orders issued, and of those, 8 contained supplemental environmental projects. These orders assessed a total of $1,402,730 in penalties, with a payable amount of $887,444. $303,159 are to be paid for supplemental environmental projects. 1,107 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 158 enforcement action referrals have been received. There are 1,801 pending administrative orders, with 302 cases that are on the backlog. 196 cases are pending at the Attorney General's office for representation in district court, and no judgment has been issued. 2,081 cases are being tracked for compliance. We have included for review a summary of OCE investigative activities for fiscal years 2020, 21, and 22. We are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Commissioner Lindley, any questions?
No questions. Thank you.
Commissioner Janeka?
None. Thanks.
Ms. Smith, has anyone signed in?
No one has signed in.
And Mr. McWhirter, what are your thoughts?
I have no questions. I appreciate the report.
Thank you. No action is necessary on this item. Ms. Cordell, thank you and your team for the report. Ms. Smith, please call the next item.
Item 42 is the consideration for publication of and hearing on the proposed amendment to 30 Texas Administrative Code, Section 7.103, the Memorandum of Understanding related to the regulation of the aquaculture industry. The Executive Director's staff is here to present this item.
Good morning. And you might check your mute button.
Chairman, it looks like Lori Fleet lost her connection.
Let's
I sent her a message.
Yeah, let's give it
put back in.
just a minute to see if she can hop back on, and if not, we'll take these items out of order.
Okay.
I'm also available. This is Jessie Spears if she's unable to hop on.
Oh, well, great. Why don't you go ahead then?
Sure. Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Jessie Spears with the Environmental Law Division, and Lori Fleet, who may or may not be on, represents the Water Quality Division. The proposed rulemaking would implement portions of Senate Bill 703 from the 87th Legislature, which removes the Texas Department of Agriculture's roles and responsibilities related to regulation of the aquaculture industry. Previously, the Texas Commission on Environmental Quality, the TDA, and the Texas Parks and Wildlife Department coordinated on regulating the aquaculture industry. This multi-agency coordination was codified in a Memorandum of Understanding in Chapter 7, Section 7.1.03. This rulemaking would revise the MOU to remove the TDA from this multi-agency coordination. Additionally, the proposed rulemaking would make additional updates to the MOU based on rule changes related to the aquaculture industry since the MOU was last adopted. These include, but are not limited to, the repeal of the permit by rule and exemptions in Chapter 321, Subchapter O, and the development of the Aquaculture General Permit Number TXG130000. Staff respectfully requests approval for the publication of and hearing on proposed amendment of Section 7.103 of 30 Texas Administrative Code, Chapter 7, Memorandum of Understanding. Additionally, staff requests authorization to make non-substantive revisions to comply with the Texas Register requirements. Thank you. We are available to answer any questions you may have.
Thank you, Ms. Spears. I have none. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
None, thanks.
Ms. Smith, has anyone signed in?
No one has signed in on this one.
And Mr. McWhirter, what do you think?
OPIC recommends approval for publication of and hearing on the proposed rulemaking to implement Senate Bill 703 as recommended by the Executive Director.
Thank you. I agree with that. This is largely a straightforward legislative implementation rulemaking, and I think we're ready to put it out for public review and comment. Commissioner Lindley?
I agree. I can.
My mute button. Likewise, I will make the motion that we make sure it's the right rule item, that we approve the publication of and hearing on the proposed amendments to 30 Texas Administrative Code, Section 7.103, Memoranda of Understanding relating to regulation of the aquaculture industry, as recommended by the Executive Director.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item 43 is the consideration of the publication of and hearing on the proposed amendments to 30 Texas Administrative Code, Chapter 114, to implement Senate Bill 604. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Nicholas Landit with the Air Quality Division. With me is Sierra Redding with the Environmental Law Division. For your consideration today are the Executive Director's revisions to 30 Texas Administrative Code, Chapter 114. The revisions would ensure that the inspection and maintenance program rules are consistent with the different forms of proof of compliance allowed by the Texas Department of Public Safety and the Texas Department of Motor Vehicles. Staff respectfully requests permission to publish the proposed revisions to Chapter 114, solicit public comment, and hold a public hearing. Thank you, and we are available to answer any questions.
Thank you, Mr. Landit. I have none. Commissioner Lindley, any questions?
No questions.
Commissioner Janeka?
No questions, thank you.
Ms. Smith, has anyone signed in to speak?
No.
Mr. McWhirter, tell us your thoughts.
OPIC recommends approval for publication of and hearing on the amendments to the Commission's Chapter 114 rules to implement Senate Bill 604 as presented by the Executive Director.
Thank you, colleagues. Again, this is a really straightforward legislative implementation rulemaking, and I think we're ready to put it out for public comment.
Mm-hmm. I'm in agreement. I've got a motion. Okay. I move that we approve the publication of and hearing on the proposed amendments to 30 Texas Administrative Code, Chapter 114, as recommended by the Executive Director.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item 44 is the consideration of the publication of and hearing on the proposed amended 30 Texas Administrative Code, Section 336.357, regarding physical protection of Category 1 and Category 2 quantities of radioactive materials. The Executive Director's staff is here to present the item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Hans Wager with the Radioactive Materials Division. With me is Amy Robinson with the Environmental Law Division. The proposed rulemaking would modify the rules regarding physical protection of Category 1 and Category 2 quantities of radioactive materials in Section 336.357 to add list of individuals that have been approved for unescorted access to the list of information for which access must be controlled, and the modified contact information of the United States Nuclear Regulatory Commission. A virtual public hearing on this proposal is scheduled for January 6, 2022. Staff respectfully recommends approval to propose the publication of and hearing on Chapter 336 Radioactive Substance Rules. Staff also respectfully requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Thank you, Mr. Wager. I have none. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
Thanks for the comment, Dr. Wager. I had one question, was just I don't care about the length of deadline of the time, but I understand the Nuclear Regulatory Commission will be coming in for the routine and the review of our program, agreement state program next spring. Will any of the compatibility rules that they require us to keep current with them, will we be current and on schedule when they come to meet with us next spring?
Yes, we will be.
Excellent to hear. I appreciate it so much. Thank you for your hard work.
But first, we have to propose this rule.
Fingers crossed. We'll see if the public has any strong feelings about us getting into compliance and full compatibility with the Nuclear Regulatory Commission. So,
well, Ms. Smith, what says the public?
No one has signed in.
No one has signed in. Okay. Well, they can comment on it when we put it out, I suppose. Mr. McWhirter, what do you think?
OPIC recommends approval for publication of and hearing on the proposed amendment to 30 TAC Rule 336.357 as presented by the Executive Director.
Thank you, Mr. McWhirter. Yeah, colleagues, as we heard, these rulemakings this rulemaking is to comply with federal requirements. Fairly straightforward. I think we're ready to put it out and see what the public thinks of it.
I will move that we approve the publication of and hearing on amended 30s Texas Administrative Code Section 336.357 as recommended by the Executive Director.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next items.
Item 45, I'll note, was continued to the December 15th agenda, so we'll be going on to items 46 through 49, which are for closed session. However, the commission is not meeting in closed session today.
With that, the time is 10:47 a.m. and we are adjourned.